In this screencast, we'll discuss the most familiar federal court, the U.S. Supreme Court, which was created by Article 3 of the U.S. Constitution. The U.S. Supreme Court is the court of last resort for both the federal system and all of the state court systems. It is an appellate court, except in rare instances when it may serve as a trial court with original jurisdiction. An example of this was the impeachment trial of President Bill Clinton back in the 90s. When the U.S. Supreme Court agrees to hear a criminal case, it is probably due to a constitutional issue contained within the case. The U.S. Supreme Court has a discretionary docket. This means that they only hear the cases they want to hear. You may have overheard or seen a person on television insisting they will take their legal case all the way to the Supreme Court if they have to. In reality, they have very little control over whether or not their case is heard by the court. The U.S. Supreme Court is the one who will determine whether or not it's heard, and if they don't want to hear it, they don't have to. The Supreme Court reviews decisions from the U.S. Courts of Appeals and state appellate courts of last resort here in this chamber. Just to give you an idea of how likely it is for a case to make it to this room, there are about 92 million lawsuits annually, with 7,000 appealed to the U.S. Supreme Court. The court only hears about 90 every year, and only 20 to 35 of these are actually criminal cases.